Good morning and welcome to Leasehold Knowledge Week. We're going to be bringing you some informative sessions this week with our live leasehold conference on Wednesday. Firstly, I would like to say a quick thank you to our sponsors, our headline sponsor, FR Consultants, event sponsors, Foresight Consulting, BBIS Heating, Beehive Block Management, Fixflow, Future Group, JM2 Group, MRI Software, PropRec, Present It, Realty Law, Tetra Consulting, and finally TNA Building Services. Today's opening session is brought to you by Shabnam Ali-Khan, partner and head of the enfranchisement team at Russell-Cooke LLP. She's going to be discussing the Landlord and Tenant Act 1987, right of first refusal. During today's session, if you've got any questions, please feel free to pop them in the Q&A button at the bottom of your screen. And we will try to get through as many as possible at the end. We are recording today's session and it will be available to watch back via the News on the Block YouTube channel later today. And that's it for now. I will now hand you over to Shabnam to begin this morning's session.
Good morning, everyone. Nice to see a few of you joining us. So that's fantastic. This is my first News on the Block webinar, and it's quite interesting to be the first one on a Monday morning. So I'm going to attempt to share my screen for the second time ever. So I'm hoping it's going to work. So just bear with me. Here we go. Okay, brilliant. So I'm going to be talking to you, as Vicky said, about the Landlord and Tenant Act 1987. It is one of the worst pieces of leasehold legislation. There's a lot of gaps in it, a lot of ambiguities, and quite a few unanswered questions. And I'm a little bit surprised personally that they didn't look at doing something about it in the sort of current wave of leasehold reforms, but what do I know? Hopefully next time they'll get to it. But okay, so what I'm going to talk about is the process itself, and towards the end, just go through a couple of scenarios where it will apply and how you might want to deal with it in practice as a practitioner. So let's begin, and I'm hoping this is going to work. Here we go. Okay, so the Landlord and Tenant Act 1987 essentially introduced the right of first refusal. There have been some more recent amendments under the Housing Act of 1996. So it hasn't been touched as a piece of legislation for a very long time, unfortunately. What it says in a nutshell is that if you have qualifying tenants in a building and the immediate landlord is proposing to dispose of its interest, that immediate landlord must serve offer notices on the qualifying tenants before they can make that disposal. So we are going to go into what an immediate landlord is. We're going to touch on what qualifying tenants are as well. So the third point on the screen is what happens if you don't qualify as an immediate landlord? And we get this quite a lot in my private practice experience. We get a lot of landlords who are quite savvy, have lots of properties, and they really can't be bothered and don't see why we need to go through this process. And it is about risk management with them. And you have to say to them, well, actually, it's a criminal offence. It's punishable by an unlimited fine. And how much of a risk that is, we will come to a bit later on. And the final point on the screen that we'll talk about is what can the qualifying tenants do when there's been a breach? So what can you do when your landlord hasn't offered you the right of first refusal? And there are some, pretty good rights under the Act to enforce against a new purchaser. So moving on from there and just touching on eligibility and qualification. So the first thing we need to look at is the premises. So what premises qualify under the Act? Now, Section 1 of the 87 Act says it has to be a whole or a part of a building. And if it's part of a building, it has to be capable of vertical division from the other parts. But the Act itself doesn't actually define building. It doesn't go into any more detail. So what we need to use is common sense and the limited case law that's there. But very broadly, it's going to be what you and I class as a building, just houses across the street containing flats, for example, big blocks of flats. So it's usually fairly obvious what the premises will be. Now, that building, those premises must contain at least 2 flats that are held by qualifying tenants. And we will come on to what is a qualifying tenant. Qualifying tenants must hold more than half the flats in the building. So that's usually fairly straightforward. If you've got 5 flats, at least 3 have to be held by qualifying tenants. And in terms of the floor area, you have to have more than 50% of the internal floor area, excluding the common parts, to be in residential use or intended to be in residential use. And again, in my experience, most of the time, it's obvious if the building falls foul of that section. You know, it's going to be if there's retail units, office spaces, that sort of thing in a building, then you need to maybe check what the floor area is going to be. So you might see some similarities between the right of first refusal so far and collective enfranchisement. And collective enfranchisement, as many of you will know, is a right that leaseholders have to actually force the sale of the freehold. But this is, you know, quite a different right. So the second bit we need to look at is then, what is a qualifying tenant? So how do you become a qualifying tenant under the Act? Now, it's very different to the collective enfranchisement criteria, and it's essentially wider. So you have to just hold a flat under a tenancy. That's pretty straightforward. So it can include your standard long leaseholders that most of us deal with, but it won't include commercial tenants. So if you have a business tenancy that falls within the 1954 Act, it won't qualify. And you've also, sometimes there can be ambiguity on that business tenancy point. I mean, I've come across leases which are mixed use, and you really need to read through the terms of that lease to see how much of it can be used for non-residential. And you may need to get, you know, specific advice on that as a leaseholder, as a tenant potentially, because if it goes over a certain amount of commercial use, it may well become a business tenancy and won't qualify under the Act. And finally, if you are a tenant that owns 3 or more flats in those premises, you will not qualify, and nor will those flats count towards the more than 50% we need. So that's quite similar to the 1993 Act. So those flats will be excluded. Again, it's very easy to establish that. And it's something that clients sort of struggle with when you're presented with an instruction with a, you know, huge block of flats, and the client just wants you to look at the right of first refusal, and sometimes they see it as quite a simple process. But if there's a lot of flats, you'll need to download all the leasehold titles and actually go through and see, you know, does anyone own 3 or more flats in the building? So you need to do all that before you see whether it applies. So moving on from there, sticking with eligibility and qualification, we then go on to what is a landlord for the purposes of the Act. Fairly straightforward. It's going to be your immediate landlord. So very simply, if you have a freeholder of a building, there's a head leaseholder and then a number of flats. If the freeholder is proposing to dispose of its interest, then obviously they will not be the qualifying landlord. They will not be the immediate landlord for the purposes of the Act. There is a resident landlord exemption under Section 58, and it's quite easy for a landlord who's an individual, for example, to fall into that exception. They've really just got to live in the building for at least 12 months as their only or main residence before the disposal is due to occur. If you have joint landlords, so you have 2 or 3 people that are landlords, in my view, they would all need to satisfy that residence test because they collectively are the landlord. So if you've only got one person that lives there and the others don't, then it's safer to assume that Section 5 notices the 87 Act is going to apply. The legislation does give us exemptions. So you've got the resident landlord exemption. Local authorities are also exempt, and the Crown is also an exempt landlord. So it's often, you know, quite clear whether the landlord qualifies or not. So moving on from there, we have the disposal. So we know the building qualifies, and we know the landlord qualifies, and we know the qualifying tenants qualify. In fact, I'm going to jump back just a bit because there's one more point on qualifying tenants, which is really important. And I forgot this when I was practicing this yesterday. And it's to do with the types of tenancy, that don't qualify. So if you're a protected tenant, you do qualify. So you have a right to be offered the right of first refusal where all the other pieces fit. But if you are an AST, so if you're holding as an assured short-hold tenant, you don't qualify. And the reason why this is important is because it does come into play when you're dealing with long leaseholders. So, for example, if you have a leasehold flat and the ground rent is more than £250, this is outside London, or it's more than £1,000 inside London, then those leaseholders are potentially holding on ASTs and will not qualify for the right of first refusal. This has come up quite a lot in my practice area recently. We've had a few clients who are sort of developers and landlords that are looking to sell their buildings, sell their properties off. And I think part of it's to do with the leasehold reforms and the introduction of the Leasehold Reform Ground Rents Act as well. It's had a bit of an effect on the market, obviously. And I had an instruction recently where it was a building that contained what were essentially hotel rooms. And the landlord was the immediate landlord. They weren't an exempt landlord. And they said, we want to sell these hotel rooms. We want to sell the freehold of the building, Do we need to offer that freehold interest to the tenants of the hotel rooms? Now, on the face of it, they were all long leaseholders. They had leases that were, I think, 125 years plus or something like that. So on the face of it, I had to go through the whole process, did the building qualify, etc. And when I started looking at a sample of the leases, they all had quite high ground rents, and they had rising ground rent clauses every 20 years or so, which effectively took them over the limits. And this was a London property. I think it was Southeast London, and those ground rents were already over £1,000. So I was like, well, actually, they're AST, so the building doesn't qualify. But just as a side note, I did look into whether the hotel rooms could be classed as dwellings. Could they be classed as flats? And there's not really much case law under the 87 Act, unfortunately, but I did find some collective enfranchisement cases which were useful because the definition of a flat and a dwelling is similar. And it was interesting because even if they didn't have cooking facilities within that, room, that unit, they could potentially still be dwellings, because the idea was that society's moved on. We don't expect people to be cooking at home in their own kitchens. There are actually quite a lot of situations where a person is regularly eating out or regularly getting food delivered in. And you also, I've come across this quite a lot, got more of these services where they actually deliver meals to your door. Sometimes it's easier for people. So on the face of it, those hotel rooms were potentially dwellings, but they fell outside the Act purely because of the AST point. So I just thought I'd mention that. I'm so sorry for missing that out earlier, actually. And that's makes them become ASTs for the purposes of the 1988 Housing Act. So I think I've sort of covered on that. And let's move on to the disposal itself. So this is under Section 4 of the 87 Act. And in order for it to be disposal that qualifies, it has to be a relevant disposal. Now, Section 4 is pretty good. It gives you a list of exempt disposals, and most situations you'll come across will fit neatly into one or the other. But essentially, it's to do with the sale of part of the building, part of the landlord's estate. It can include common parts. Come on to that a little bit later on. Classic exclusions are if you're granting a single lease of a flat. So if you're in that situation, there will be no need to offer the right of first refusal to the leaseholders first. Another common exception that we come across is if the freeholder, or the immediate landlord rather, is a company and they are proposing to dispose of their interest to another company that's been associated with it for at least 2 years. So that's something to bear in mind. It comes up quite a lot, so that's important. Also, sticking with companies, if you have a company that's gone into liquidation, then the disposal to the liquidator is exempt. Another example of an exempt disposal is if you're an individual and you're gifting the property, you're gifting your interest to someone in your family. So that could be a child, it could be a spouse, it could be a parent. And the Act does give us a definition of, who counts as family members. And it does also include civil partnerships, for example. So that's quite good, quite useful. It also doesn't apply if you're a group of leaseholders as a family. So say 3 members of a family own a property and they're proposing to transfer it in a way to change that combination, but sticking with the same family. So they might take someone out of the register, they might introduce another family member in. So that is exempt. Another example, which you may come across in your practice, is where you have trustees that own a property. The discharging of a trustee or the appointment of a new trustee will be exempt. Now, I mentioned about common parts. This comes up quite a lot. We have instructions where a landlord is proposing to sell a common part of a building, or what they think might be a common part. And you do need to really look at whether it is, because that's what it hinges on. Is the landlord disposing of a common part? Now, if it's a common part, say, gardens, for example, that are next to your block of flats, your building of flats, if that area is capable of being used in common by, at least a couple or a number of flats, it's usually going to be seen as a common part. But if you've got part of a building, just as let's say as a gym, in the bottom of the building, there's a gym. If it's only the people in the building that have a right to use that gym, then the sale of that gym is a common part and it will trigger the right of first refusal. But if that gym is also used by independent people, third parties coming in, then it won't be a common part. So those are the sort of things you need to explore, obviously, when these kinds of instructions come across your desk. I had one recently where the client was a freeholder. They were the immediate landlord in this scenario. They had a block of flats. It was quite a big block, actually, sort of like an L-shaped block. And they had an adjacent car park area, sort of to the rear of the building. Now, that car park area had a number of car parking spaces. And one leaseholder in the block had a car parking space in that area. Nobody else did. And that leaseholder had rights to use that, to go through the area into their car park. And the question was the sale of the car parking area caught by the Act? Now, my research on the face of it said probably not, because it was only used by one person. They still have rights to use it. And presumably those rights would be in any transfer to an independent third party. It might have messed it up a little bit. I've got a flat in the building, but another freeholder has a car park that I've got a right to use. But it was just an interesting one, just looking at, what is a common part. It's not always straightforward. It's not always clear cut. And going on from there, as I've said on the slides, if you are in a building containing flats and the top floor flat wants to acquire the loft space, so it's not already part of their demise, is the sale of that loft space, presuming this is an immediate landlord and everything, is the sale of the loft space caught by the Act? And on the face of it, it will be. And I've just put a little quote in there because it's something that we get with clients sometimes, where you have groups of leaseholders that own the freehold, usually as a company. So they've all got shares in that company. and the top floor flat wants to buy the loft space because they want to convert into it. And the question they always have is, you know, we're okay with it. We don't have a problem. We've actually, you know, got a premium in mind. Everybody's happy. Technically, that loft space is caught by the Act. So they do need to offer it first. And I'll come on to that a little bit later on, actually, in terms of, in practice, how you deal with those kinds of situations. But the final slide, point on the slide, sorry, is what happens if it's a commercial lease that's being disposed of. Now, the Act does not specifically say that that's exempt. So on the face of it, you should still offer it. And that's what I do when I get similar inquiries. We play safe and we offer it to the leaseholders first. We've never had a scenario where the leaseholders have accepted the sale of a commercial lease, because most of the time they're not bothered. They're not really interested in starting to look after a commercial premise. Okay, I've just noticed we've got a question. Let's have a look if it's something we can look at now. Just bear with me. Yeah, so this is a question that basically says, it goes back to the AST point. So if a central London flat that pays over £1,000 in ground rent is regarded as an AST for the purposes of the right of first refusal, does this mean that other AST remedies and law also applies in the context of arrears or breaches of the lease? Now, that's a really good question, and we've come across that a few times. I've spoken to other solicitors about this, and I think the general consensus is probably yes. So rights to terminate, for example, you know, there's much more, it's much easier to terminate an AST than it is to terminate, you know, forfeit a long lease. So I think potentially those rights would still apply. It's not concrete anywhere, but that is the general school of thought. So it's quite interesting, actually, just to stick with that for a little bit longer, because, you know, many of you are aware that we've had the, you know, ground rent scandal, and that's part of the reason why we've got the Leasehold, you know, Reform Ground Rents Act that's actually come into force. It's not going to kick in for another sort of 4 or 5 months or so, and that's proposing to remove ground rents. And it's interesting because you do have a lot of people currently that have such high ground rents that are potentially going to become ASTs. I don't know how aware the buyer's market is on this. I think people tend to be more scared of buying rising ground rent properties because of the lending, you know, worries and selling it on. I think this whole AST issue is still fairly under the radar, but it's something that I do pick up on, and, you know, I'll make sure that our conveyancing team is aware of it. We work quite closely with them. But yeah, thank you for that question. I hope that was a satisfactory answer. Lovely. So let's move on to the next slide, if it's going to let me click. Brilliant. So just keeping on with the process now. So we've talked about what the premises are. We've talked about what could be an immediate landlord, you know, who are qualifying landlords. We've also talked about the qualifying tenants and what the potential disposals are. So what happens next? So you as a landlord know that you have to go through the Section 5 process. There are quite a few different sections to this. I'm just going to touch on a few sort of the main examples. Sorry, just having a sip of my now slightly cold coffee. So with Section 5, you've got Section 5A, you'll see up on the screen. Really popular example of a Section 5, and that's where your immediate landlord is proposing to dispose of its interest with a contract. Now, in the notice itself, you must outline the principal terms of the disposal. That's usually going to be the deposit, if there is one. It's also going to be the consideration. And it might be if you want the other side to pay costs. So if the purchaser's going to cover a certain amount of your costs, in my view, that's a principal term of the disposal. It should go in the notice. What we normally do, and this is a right of first refusal is a tricky one, and it can get quite awkward if you're dealing with solicitors on the other side who have different views on the right of first refusal. As a firm, Russell-Cooke, and even in my previous firm, Alan Edwards and Co., we always play fairly safe when we're doing Section 5As. So we make sure the contract is agreed. So if, for example, you're acting for a landlord and they've already got a buyer waiting in the wings, then we make sure that contract is agreed before we serve Section 5 notices, so we can also attach that contract to the notice, because that avoids any issues of, you know, the leaseholders or the tenants weren't notified of a particular term. Now, not all solicitors, I've noticed, do that, and not all solicitors agree with that, and not all solicitors, worryingly, kind of appreciate why you should do that. I give you an example. It's a real life example of an instruction that I'm dealing with, and it's a building containing flats. They all have a share in the freehold. So it was a bit of a nightmare trying to convince them that the right of first refusal still applied. They all were happy for not to serve Section 5 notices. But, and this is a big but, there's no express provision in the Act for tenants to waive the right of first refusal. There probably should be. I think it would be a good thing if there was a section that said, you know, words to such effect, or a prescribed form that you could send to your immediate landlord to say, we don't care about Section 5. But in this case, obviously, we said we've got to do Section 5 notices. And what we're doing in this case, it's quite a complex one. It's a block of flats with a sort of area of gardens. And in that garden, there's a structure. So it's just like a room. It's a big room. And what the landlord wants to do is to sell that room to a buyer. And the buyer is then going to knock it down and build a house in its place. So on the same footprint, essentially. And there's a contract. There's also a transfer to show that they're then going to become the transferee of this building. And it's going to become a house. So there's quite a few documents that we've been bashing back and forth. And the solicitor on the other side, I noticed, is in a different department. So he doesn't actually specialise in right of first refusal. Kept banging on at me for months to say, look, can we just serve the Section 5 notices so the time limits start going, so the clock starts ticking? We haven't agreed the contract. We had a development lease that wasn't agreed. We also had a license for alterations, because once they bought the room, they were then going to enter into a license to convert it into a house. There was planning permission and all sorts. And this solicitor just wouldn't understand and kept saying, you're just wasting time. We could have already got to the acceptance notice. And it took a lot for me to convince him that you can't serve a Section 5 notice with a contract when you haven't even agreed the terms of that contract. Because if you do serve a notice prematurely with what you think are the terms, what if something changes afterwards? You know, your buyer in the wing says, oh, what about this? Or what about arrears? Or, you know, whatever. You then have to start the whole process again. So it is quite interesting to see the different views people have. So I just thought I'd touch on that because it was, you know, it's very relevant and it comes up quite a bit. And I'd be interested to know what your experience is as well. But very basically, when you're entering into a contract, the consideration is going to be monetary. So there's going to be a premium payable. As an immediate landlord, you have to place a date for acceptance in the notice. It's basically 2 months from the service of the notice, and that 2 months runs from when the last person receives the notice. You then have to give a further 2 months for the tenants as a majority to nominate a purchaser. And that's usually going to be either the joint names or it's going to be a company that they form. But you can actually nominate the purchaser in the acceptance notice if you have the purchaser already set up. And finally, it's the requisite majority that need to accept. It's got to be one notice from the requisite majority. So I get a lot of situations where we serve Section 5 notices and it might be one leaseholder comes back with a letter or an email to say, I'm up for it. What do I do next? But it has to be one notice. So it's got to be one notice on behalf of the group. So the next type of Section 5 notice that I thought it was worth running through is under section 5B, and that's the auction process. And this one's a little bit strange to explain to clients because it's different, isn't it, really? It's not we're offering it to you in the same way, in the cleanest sense. What it means is when your landlord is proposing to dispose of the interest at auction, you've got to, again, list the principal terms, but there'll be fewer here because you won't know the premium, you won't know the consideration. There's also no requirement to put in a reserve price in the notice. So the principal terms will probably be a little bit more straightforward. It might be, this is the building it relates to. There may be something about costs. There may be the usual provisions, paying all service charge arrears or whatever, but you may usually get, that depends on the terms, I suppose, of the auction contract. But what the process is for section 5B is similar to section 5A. So you still give a period of acceptance, the 2 months still applies, the nominee purchaser process still applies. You still need the requisite majority to accept. But what's different is that you're giving the requisite majority the opportunity to replace the bidder at the auction. So if you accept a section 5B notice, you're not immediately stepping into their shoes. What you're accepting is an offer later down the line to step into their shoes. Because if you've accepted the offer and then it goes to auction, the landlord will then send you a copy of the contract and say, look, do you want to get involved? Are you still interested? Because that's when you know what the premium is and, other bits like that. And what's really important is if you have accepted the offer, you have to serve a further notice. So you serve your section 6 acceptance notice, but you also have to serve a section 8B notice no less than 28 days before the auction. And that is a further notice to say that, yeah, we're still in and we want the auction procedure to apply. If you don't serve that notice, on behalf of the qualifying tenants, it's a deemed withdrawal from the process. Now, what does that mean? Well, it basically means you no longer have the right to be offered to replace the successful bidder. Now, the other side of it is, well, you could still rock up at the auction and you could still bid. The leaseholders or the tenants can still do that. But the downside is that they have less time really to get their funds together and enter into that contract. So that's, one of the risks of it. So just bear that in mind, because I've noticed it's not something that's glaringly obvious, because when you get a section 5B notice, the landlord doesn't remind you that you have to serve this section 8B if you want to. And just the final point on this slide is the landlord won't necessarily know the details of the auction when they serve you with the section 5B notice, but they do need to provide that to you before the auction. So you will be notified. Now, this notice itself, the section 5B, must be served between 4 and 6 months before the auction. Okay, so no less than 4 months, and between that 4 and 6 months. So those are the sort of the main types of offer notices. There is also, section 5 has different subsections. Another one just maybe worth touching on is section 5D. And section 5D is where the landlord is proposing to sell the property, but there isn't going to be a contract, so it might just move to a straightforward transfer. Okay, so let me just... Okay, so we've got something in the chat, and it's a point basically which, and I'll just read it to you. This is just going back to the auction process, section 5B. Would it really not be wise for leaseholders to bid at auction, as this will have the effect of increasing the price? Now, that's a really good point, and it's something that I came across in reality a while ago. I had some leaseholders who'd actually instructed too late. So they'd missed the boat for serving Section 6 notice. They'd missed the boat for serving a Section 8B notice. So the only option they had was actually to go to the auction and bid. Now, the problem is, even if you have accepted the offer, if you bid at the auction, there is a danger. So let's say, for example, you don't serve the Section 8B notice, it's been forgotten. Let's go to the auction. But exactly as the person said in the chat, the risk of doing that is that you are pushing up the price. Because say, for example, you have two strong bidders, a bidder A, bidder B, and they keep bidding, and the price is going up. If the group of leaseholders is also bidding, they're just going to cause that price to go higher. So in my view, I think one of the other risks of not serving a Section 8B notice is that even though the leaseholders can go to auction, that price is going to be higher than they would have been paying had they served the Section 8B. Because if you are a buyer at auction, you will know that the leaseholders have exercised, the tenants rather, have exercised the right of first refusal, because it will be in the pack. But if they haven't served the Section 8B, then it makes it a more attractive prospect than if they had. Because if they serve a Section 8B, as a bidder, as an interested buyer, that you could keep bidding and pay the highest price, or be willing to pay the highest price, but the group of tenants can just take it for that price. But yeah, that's absolutely right. A property is going to be more attractive on the open market at an auction where there's been no Section 8B served. Okay, thanks for that question. That was really useful. So we're going to move on to the next bit. So acceptance notice. So acceptance notice, Section 6 of the Act. Same as Section 5 notices, there are no prescribed forms for any of these. So you just have to follow Section 6. It's really straightforward, actually, the acceptance notice. If you accept, it's got to be by the majority. So you can't just as an individual say, I'm up for it. It's got to be the majority. You've got to get together. In practice, it's really hard when you're instructed on these on behalf of tenants, because they sometimes sit on notices for several weeks, and sometimes they just take ages to coordinate themselves. And I often find that you'll get right of first refusal instructions when you've only got 2 weeks to serve the acceptance notice, and you're trying to get ID and all the KYC documents. So the acceptance notice served on behalf of the majority of tenants. It's got to be served within that period unless a longer period is agreed, and it can include the details of the nominee purchaser, as I mentioned before. So what does that mean if we serve an acceptance notice? Well, it effectively stops the landlord from disposing of that interest within 12 months following that acceptance period. So the landlord is effectively tied in for quite a long time. Now, what does disposing mean? And the reason why I touch on this is because it's come up in one of my matters. A really obvious example is if, say, the landlord serves a Section 5 notice, the leaseholders accept, and we're sort of moving to the contract. What happens if, between serving the notice, the landlord then sells the whole building? Obviously, that's a breach of the right of first refusal. But if they change the structure of the building, that, in my view, is also a breach. I've got one at the moment where the freehold is of the building. There's like 9 or 10 flats. There's a commercial unit below, and we've accepted the offer. We're just trying to move to and entering into the contract. And what the landlord has done in the interim is actually, so they're proposing to surrender one of the commercial leases because it's in the same name, and actually re-grant a new lease to a third party, which completely changes the premium. It makes that property worth less now because the landlord's carved it up in such a way. And again, I had to have a bit of a ping pong with the other side to say, well, it is a breach. You need to reserve Section 5 notices. But what you'll find sometimes is that parties sometimes can enter into agreements, and things can work out. But in that particular case, they're actually going to reserve. So I'm not looking forward to telling my clients that they're going to have to pay extra fees because there's going to be a new contract to consider and a new transfer. Okay, so let's move on from there. So what happens if there has been a breach? So what happens if the landlord hasn't served the notice or they've not complied with the process fully? You can, as a requisite majority, serve Section 11A information notices. And you see from the screen, you know, the timeframes for serving those notices. And an information notice is basically what it says on the tin. It's a notice that you give to your the immediate landlord, which is actually the new landlord at this point, to say, how did you buy it? What were the terms? When did this happen? And they have to respond. Okay. If the new purchaser doesn't respond, it's a criminal offence. The requisite majority can also serve a Section 12A notice to take benefit of the contract. Now, you'd usually do the 11A first if you really need to have more information, and then you'd move to the Section 12A. Now, I had this in one of my matters recently where we served the Section 11A. We thought there was a breach. My clients thought there was a breach, but we just needed more information. And bizarrely, the solicitors firm that were acting for the freeholder now just had they said the previous firm that dealt with the breach disposal didn't have the file, which I was really surprised about. It was 6-7 years ago. They should have had a copy of it. They didn't have the contract. They no longer had the file. But, and this was really good, we didn't have to go down Section 12 route. They just agreed that they would reserve a Section 5 notice for a lower premium. So everybody was happy. So we reached an agreement. So you'll see on the slides the timeframes. I won't go into that. It's fairly obvious from the slides. You can also serve a Section 12B notice, which is a purchase notice to compel the sale. And again, the timeframes are quite similar. Now, Section 3A notice is mentioned on the slides, and that's under the 85 Act. And that is an obligation on a new landlord to let you know that they are the new landlord. And that's roughly when the leaseholders may find out that, hang on a minute, we didn't get offered the freehold first. So that's when it might be, this is possibly a breach. And the final point on that slide is the criminal offence point. So I touched on this before. Now, this comes up quite a lot with my clients when they don't really want to bother with the right of first refusal. It's usually a paper exercise in some situations. But the reason why we err on the side of caution is because it's a criminal offence with an unlimited fine. Now, this was brought in by the 96 Housing Act. And as far as I'm aware, there's never been a prosecution on this point. Now, that could be because people aren't bothered. So the tenants in the building are not really bothered that there's been a breach. And they're not really bothered about chasing the old freeholder or the old landlord for the fine aspect. And it may also be that people don't know about it, because you don't always associate criminal offence with property in terms of sales. And the other reason, I think, is because it's the timeframes. You've got to start these proceedings within 6 months from the date of the disposal, the date of the breach. You're not necessarily going to know that. It's happened for some time. Okay, now we've come on to the question slide, but I just wanted to touch on that loft space example, because I think it's quite important and it comes up quite a lot. We get a lot of situations where leaseholders collectively own the freehold as a company, and they're quite happy for the top flat to just buy the loft space. It is a disposal under the Act, so they do need to serve Section 5 notices. It is a bit of a paper exercise because sometimes in that building, no one really cares. They're quite happy for that person to have the loft space, but you should still go through the process. And what we would do, and I'm sure other firms do things differently as well, there's different views on this, but we normally do it as a supplemental lease. So we would draft the supplemental lease of the loft space. And that lease will basically refer to the flat lease and to say, the terms apply, it's the same terms, etc. And it will also have a clause in there to say that you can only use that loft space in connection with that flat, and you can only sell it together. So you can't sell it independently. So that's how we would do it. we'd have the supplemental lease as the disposal that we're offering. We just do it, nobody accepts it, and then we can sell on to the owner of the top floor flat. But if they want to do works into that loft space, if they want to do a conversion, there may need to be a separate license to alter. Also, if their conversion is going to be tampering with the structure, you need to make sure that the demise of the loft includes possibly the structure. So it's just something to think about. I'm just going to check my notes to see if there's anything else that I wanted to mention. No, I think that's it really, guys. So I'm pretty much done. It's just coming up to 11:15. If anyone's got any comments, any questions, I'll do my best to answer them. So it's over to you. Thanks very much for listening. Oh, we've got... Hi, Vicky.
I was just going to say, I'll wait for a minute and see if any questions come in.
Okay, we don't have any questions yet, but please do feel free to put anything in the chat, put anything in the Q&A box.
No questions. I think that's a good sign. I think that means
brilliant. I'm happy with that.
You've covered everything that.
I'm happy with that. That's good. That's really good. Well, I hope it was useful. Thanks very much, everyone.
That's okay. Thanks so much for your time, Shabnam. I hope everyone found it useful, and thank you all for joining us today. Unfortunately, this afternoon session on property disputes and mental health is going to be rescheduled as Laura Seven is unwell. However, I will notify you of the new date, and hopefully you can join us tomorrow. Tomorrow we have reinstatement cost assessments with El Kendrick at 10 o'clock and license for alterations in the afternoon at 2 o'clock with Osborne's Law. So thanks again, Shabnam, for your time today, and I will see you all tomorrow.
Brilliant. Thanks, everyone.
Thanks.
Take care.
Bye.
Thank you. Bye.